The gavel's echo still hung in the air when it happened. Attorney Isaiah Bennett stood at the defense table in courtroom 4B of the Cook County Criminal Courthouse. His charcoal three-piece suit was immaculate, his burgundy tie perfectly knotted. The leather portfolio in his hands contained the final motion that would secure his client's freedom. It was 10:47 a.m. on a Thursday morning in downtown Chicago. The courtroom smelled of old wood polish and recycled air. Afternoon sunlight streamed through the tall windows, casting long shadows across the mahogany benches. Isaiah had been practicing law for 12 years. He'd argued cases before the Illinois Supreme Court, won precedent-setting civil rights verdicts, and built a reputation as one of Chicago's most formidable defense attorneys. His track record spoke volumes: 89% success rate in criminal defense cases, pro bono work that had freed 7 wrongfully convicted individuals, and recognition from the Illinois State Bar Association for excellence in advocacy. The case before Judge Margaret Sullivan that morning should have been routine. His client, a 19-year-old college student named Derek Holmes, faced misdemeanor charges that Isaiah knew would be dismissed. The evidence was weak, the prosecution's case full of holes, and the arresting officer's testimony contradicted the video evidence Isaiah had obtained. Judge Sullivan was known for fairness and efficiency. At 56, she'd served on the bench for 18 years and had earned respect from both prosecutors and defense attorneys. Her courtroom ran with precision, her rulings grounded in law rather than prejudice. But Officer Kyle Brennan didn't belong to Judge Sullivan's regular court staff. Brennan was 38 years old, with 14 years on the Chicago Police Department. He'd been assigned to courtroom security duty for the past 3 weeks, a temporary reassignment following an internal investigation into use of force complaints. His personnel file, which Isaiah had reviewed during discovery, showed a pattern: 12 citizen complaints in 5 years, 3 sustained findings of excessive force, 2 suspensions without pay. The complaints shared common themes: escalation of minor situations, disproportionate responses to perceived disrespect, and a troubling pattern regarding which citizens received his harshest treatment. Isaiah approached the bench to submit his motion to dismiss. Standard procedure. He'd done this thousands of times in his career. Judge Sullivan was reviewing documents, her reading glasses perched on her nose. The prosecutor, Assistant State's Attorney Richard Lawson, stood to her left, waiting his turn to respond. Isaiah moved forward with the confident stride of someone who belonged exactly where he stood. That's when Brennan stepped into his path. The officer's hand came up suddenly, making contact with Isaiah's chest. Not a light touch to redirect, but a forceful shove that sent Isaiah stumbling backward 3 steps. His portfolio fell, scattering papers across the polished floor. The courtroom went silent except for the flutter of falling documents. Isaiah caught his balance and looked up at Brennan. The officer's face showed no surprise, no apology. His expression carried something else entirely: satisfaction. "Back up," Brennan said loudly. "You don't approach the bench without permission." Isaiah's heart rate spiked, but his voice remained controlled. "I'm counsel for the defense. I have every right to approach." I said, "Back up." Brennan's hand moved to his belt, fingers brushing the handcuffs attached there. "Don't make me tell you again." The bailiff, Andre Lewis, moved forward quickly. Andre had worked this courthouse for 20 years and knew courtroom protocol better than anyone. His expression showed clear confusion. "Officer Brennan," Andre said carefully, "defense counsel is permitted to approach the bench during proceedings." Brennan didn't look at Andre. His attention stayed fixed on Isaiah with an intensity that transcended professional duty. Judge Sullivan's gavel struck once, sharp and commanding. "What is happening here?" Her voice cut through the tension. "Officer Brennan, why did you lay hands on defense counsel?" Brennan straightened. "Your Honor, the defendant was approaching in an aggressive manner. I was maintaining courtroom security." Isaiah felt the familiar weight of injustice settle onto his shoulders. He'd been in this position before, not as an attorney, but as a young man growing up on Chicago's South Side. The assumptions, the suspicion, the immediate escalation based not on actions, but on perceptions shaped by bias. But this was different. This was a courtroom, a place where law and order were supposed to reign supreme. This was his professional environment, where his credentials and expertise should speak louder than any prejudice. Your Honor, Isaiah said, his voice steady despite the adrenaline coursing through his system. I was simply approaching to submit a motion, as is standard procedure. There was nothing aggressive about my approach. The court reporter, Linda Ashford, had stopped typing. Her hands hovered over the stenography machine as she watched the scene unfold with wide eyes. Judge Sullivan removed her glasses and leaned forward. Officer Brennan, I've been presiding over this courtroom for 18 years. I know when an attorney is approaching appropriately. Mr. Bennett was doing exactly what he's supposed to do. Brennan's jaw tightened. With respect, Your Honor, I'm trained to identify threatening behavior. That individual was moving too quickly toward your position. That individual, not counsel, not Mr. Bennett, not the defense attorney. That individual.
The courtroom spectators shifted in their seats. Several pulled out phones, recording despite the no photography rules. A young law student in the gallery leaned forward, her expression mixing shock and recognition. She understood she was witnessing something significant. Isaiah bent to collect his scattered papers. His hands were steady, his movements deliberate. Years of experience had taught him that responding to provocation with anger only confirmed biases in the minds of those looking for confirmation. As he gathered the documents, Brennan spoke again. Your Honor, I recommend this individual be held in contempt for disrupting court proceedings. The audacity of it hung in the air like poison gas. Isaiah straightened slowly, papers in hand. He looked directly at Judge Sullivan, bypassing Brennan entirely. Your Honor, for the record, I am a licensed attorney admitted to practice before this court and the Illinois Supreme Court. My bar number is 847293. I have appeared before you at least a dozen times over the past 3 years. I was performing a routine function when Officer Brennan physically assaulted me without cause or provocation. Judge Sullivan's expression had transformed from confusion to something harder, sharper. Her 18 years on the bench had shown her many things, but this blatant disregard for courtroom protocol and professional courtesy crossed lines that couldn't be uncrossed. Officer Brennan, she said, her voice dropping to a dangerous quiet, you just put your hands on an officer of this court in an aggressive manner without justification. Do you understand the gravity of what you've done? Brennan's confidence didn't waver. I understand I was doing my job, Your Honor. Maintaining security is my primary responsibility. Andre Lewis had positioned himself between Isaiah and Brennan, his body language protective. The experienced bailiff had seen enough to know this situation could escalate further if not carefully managed. District Attorney Richard Lawson cleared his throat. At 52, Lawson had prosecuted cases for 3 decades and knew courtroom conduct when he saw it. Despite being Isaiah's opponent in this case, he understood that what just occurred transcended adversarial relationships. Your Honor, Lawson said carefully, for the record, Mr. Bennett's approach to the bench appeared entirely appropriate from my vantage point. His movements were consistent with standard courtroom protocol. The prosecutor's statement carried weight. When opposing counsel defended you, everyone present understood something extraordinary had happened. Jessica Holloway sat in the press gallery, her recorder capturing every word. She'd covered the criminal courts beat for the Chicago Tribune for 8 years and had developed instincts for recognizing significant stories. This was significant. Isaiah met Judge Sullivan's eyes. In that moment, an understanding passed between them. She'd seen his work, respected his professionalism, and knew exactly what had just occurred and why. Mr. Bennett, Judge Sullivan said formally, please approach the bench now, and Officer Brennan, you will stand exactly where you are and not move. Isaiah walked forward, his steps measured and deliberate. He maintained eye contact with the judge, ignoring Brennan's presence entirely. At the bench, he handed Judge Sullivan the motion to dismiss. She accepted it, her expression neutral, but her eyes reflecting anger at the violation of her courtroom's decorum. Thank you, counsel, she said. Then she turned her attention to Brennan. Officer Brennan, I'm ordering you to stand at the back of the courtroom. Bailiff Lewis will handle any necessary security functions for the remainder of this hearing. Brennan's face flushed red. Your Honor, I'm assigned to this courtroom. My supervisor— I don't care who your supervisor is, Judge Sullivan interrupted. In this courtroom, I am the authority. You will move to the back now, or I will have you removed entirely. For a moment, Brennan didn't move. The tension in the room ratcheted tighter. Several spectators held their breath, waiting to see if the officer would defy a direct judicial order. Finally, slowly, Brennan stepped backward. But his eyes never left Isaiah, and the hostility in his gaze was unmistakable. Isaiah returned to the defense table. His client, Derek Holmes, stared at him with wide eyes. "Mr. Bennett," Derek whispered, "are you okay?" Isaiah nodded once, his face composed, but his mind was racing through options, calculating responses, preparing for whatever would come next. Judge Sullivan reviewed the motion to dismiss. The courtroom remained unnaturally quiet as she read through Isaiah's legal arguments. After 3 minutes, she looked up. "This motion is well-founded. The evidence presented by the state is insufficient to support the charges. The video evidence contradicts the arresting officer's testimony on multiple material points." She turned to District Attorney Lawson. "Mr. Lawson, does the state wish to respond to this motion?" Lawson stood. "Your Honor, after reviewing Mr. Bennett's motion and the supporting evidence, the state concedes that our case has significant weaknesses. We don't oppose dismissal." Judge Sullivan's gavel fell once. "The charges against Derek Holmes are dismissed with prejudice. Mr. Holmes, you're free to go." Derek exhaled, his relief palpable. But the victory felt hollow given what had just transpired. As the formal proceedings concluded, Judge Sullivan made an announcement that would change everything. "This court will now address the matter of Officer Kyle Brennan's conduct." Officer Brennan approached the bench. Brennan moved forward slowly, his expression mixing confusion with defiance. "Officer Brennan, you physically assaulted an attorney in my courtroom. You disrupted judicial proceedings. You disrespected the dignity of this court and violated the professional courtesy owed to counsel." Judge Sullivan's voice carried the weight of absolute authority. "I am holding you in criminal contempt of court. Bailiff Lewis, place Officer Brennan under arrest." The courtroom erupted. Spectators gasped. Phones captured every moment. Jessica Holloway's recorder documented judicial history being made. Brennan's face transformed from confident to shocked. "Your Honor, you can't—" "I absolutely can, and I am," Judge Sullivan said firmly. "You are under arrest for contempt of court. You will be taken into custody immediately." Andre Lewis approached Brennan with handcuffs. The irony wasn't lost on anyone present. The officer who had threatened to handcuff Isaiah minutes earlier was now being restrained himself. "This is ridiculous," Brennan protested as Andre secured the cuffs. "I was doing my job. I was protecting the court." "You were assaulting an attorney," Judge Sullivan countered. "There's a difference, and your inability to recognize that difference is exactly why you're being arrested." Isaiah stood at the defense table watching as Brennan was led away. The officer's eyes found his one last time, and the hatred in that gaze was pure and undiluted. As Brennan disappeared through the courtroom doors, Judge Sullivan addressed Isaiah directly. "Mr. Bennett, please approach." Isaiah walked forward, unsure what would come next. "Counselor, I apologize for what occurred in my courtroom today. That behavior was unacceptable and will not be tolerated. I want you to know that I will be filing a formal complaint with the Chicago Police Department regarding Officer Brennan's conduct." Isaiah nodded. "Thank you, Your Honor. Furthermore," Judge Sullivan continued, "I'm ordering a full review of courtroom security protocols. If Officer Brennan's behavior today reflects larger systemic issues, they will be addressed." She paused, her expression softening slightly. "Your professionalism in the face of that provocation speaks to your character, Mr. Bennett. This court recognizes and appreciates your restraint." As Isaiah left the courtroom with Derek, reporters crowded the hallway. Jessica Holloway reached him first. "Mr. Bennett, can you comment on what just happened?" Isaiah stopped, considering his response carefully. What he said now would be recorded, quoted and analyzed. His words would carry beyond this moment. What happened in that courtroom today is something that happens to black professionals across America every day. The difference is it happened in front of a judge who recognized injustice and acted swiftly to address it. Judge Sullivan's response demonstrates what accountability looks like. He paused, choosing his next words with precision. But let's be clear about something. If Officer Brennan had shoved a white attorney, we wouldn't be having this conversation. The incident wouldn't have occurred. That reality is what we need to confront as a society. The reporters scribbled notes, recorded audio, captured video. This story would run on every Chicago news outlet by evening. Derek Holmes stood beside Isaiah, still processing his freedom and what he'd witnessed. "Mr. Bennett," Derek said quietly, "thank you for staying calm. I don't know if I could have done that." Isaiah looked at his young client. Derek was 19, studying engineering at Northwestern University, his entire life ahead of him. This experience would teach him lessons no classroom could provide. "Derek, what you witnessed today is why we fight these fights in court, why we document everything, why we insist on justice even when it's uncomfortable or inconvenient." He placed a hand on Derek's shoulder. "You're free because the evidence supported your innocence. But justice requires more than evidence. It requires people willing to see truth even when it challenges their assumptions." As they walked down the courthouse steps, Isaiah's phone buzzed constantly. Messages from colleagues, former clients, community leaders. Word was spreading fast, but Isaiah's mind was already moving forward, calculating the next steps. Brennan's arrest was just the beginning. The real question was what would happen next, and whether this moment of accountability would lead to lasting change or fade into another forgotten incident in a long history of similar confrontations. The afternoon sun felt warm on his face as he reached the street. Chicago continued its daily rhythm around him, indifferent to the small drama that had just unfolded in one courtroom. But Isaiah knew better. Small dramas had ways of becoming significant movements when the right elements aligned, and something told him this story was far from over. Isaiah Bennett's path to courtroom 4B began 34 years earlier on Chicago's South Side. He was born in Englewood, a neighborhood where survival required intelligence, resilience, and an unwavering belief that circumstances didn't define destiny. His mother, Ruth Bennett, worked 2 jobs to support Isaiah and his younger sister, Alicia. Ruth cleaned office buildings overnight and worked retail during the day, sleeping 4 hours between shifts. Isaiah's father had left when Isaiah was 3. No explanation, no contact, no child support. Just gone. Ruth never made excuses. She simply worked harder, loved fiercer, and demanded excellence from her children with the intensity of someone who understood that margin for error didn't exist in their world. "You're going to be something," she told Isaiah repeatedly throughout his childhood. "Not because the world will give it to you, but because you'll earn it, despite everything the world puts in your way." Isaiah was 7 years old when he first encountered police in a way that shaped his understanding of justice. He'd been playing basketball at the neighborhood park when officers rolled up on a group of teenagers nearby. One officer grabbed a 15-year-old named Marcus, slamming him against a squad car for no reason Isaiah could discern. "He wasn't doing anything," Isaiah told his mother that evening. "They just grabbed him." Ruth sat Isaiah down at their small kitchen table. The linoleum was cracked, the chairs mismatched donations from their church. But Ruth's words that evening carried more value than any expensive furniture could provide. "Baby, the world isn't always fair. Sometimes people with power use it wrong. Your job is to be smart enough to survive it and strong enough to change it." Isaiah carried those words through elementary school at Marcus Garvey Academy, where he earned straight A's, despite classrooms overcrowded and textbooks outdated. His teachers recognized something special in the quiet boy who devoured every book he could access. Mrs. Helen Douglas, his 5th-grade teacher, pulled Ruth aside one afternoon. "Isaiah needs opportunities beyond what we can provide here. He's gifted, Mrs. Bennett, truly gifted." Through Mrs. Douglas's advocacy, Isaiah earned a scholarship to Lincoln Prep, a prestigious private school on Chicago's North Side. He was 11 years old when he first rode the train from Englewood to Lincoln Park, watching the city transform around him through the windows. The neighborhood changed from boarded buildings to renovated brownstones. The people changed from faces like his to faces that looked nothing like his. The opportunities changed from limited to limitless. Lincoln Prep challenged Isaiah in ways Englewood schools couldn't. The resources were abundant: new textbooks, computer labs, science equipment, college counselors. But the social challenges were equally significant. He was one of 3 black students in his grade of 120. The other 2 were children of doctors and lawyers, kids who spoke differently, dressed differently, and seemed to navigate the white-dominated environment with an ease Isaiah couldn't access. His clothes came from thrift stores while classmates wore designer labels. His lunch was packed leftovers while others bought catered meals from the school cafe. His cultural references came from Englewood while theirs came from vacation homes and European travel. But Isaiah adapted. He learned to code switch, shifting his language and mannerisms to fit different environments. He learned which parts of himself to share and which to protect. He learned that survival sometimes meant making yourself smaller to avoid threat. Jonathan Blake befriended Isaiah in 7th grade. Jonathan was white, wealthy, and genuinely kind. His family owned a chain of car dealerships across Illinois, and their Lincoln Park mansion had more bathrooms than Isaiah's entire apartment building had units. "Why do you talk differently sometimes?" Jonathan asked one day after school. Isaiah considered the question carefully. They were 13 years old, and this conversation could define whether their friendship continued or fractured. "Because the world treats me differently depending on how I talk," Isaiah answered honestly. "If I sound too black around certain people, they make assumptions, bad assumptions." Jonathan frowned. "That's stupid." "Yeah," Isaiah agreed, "but it's also reality." Jonathan's father, Daniel Blake, took an interest in Isaiah. He offered mentorship, exposed Isaiah to business concepts, and modeled what professional success looked like. Daniel was the first person to suggest Isaiah consider law school. "You've got the mind for it," Daniel told Isaiah during his sophomore year. "The ability to see patterns, analyze complex information, argue persuasively. Those are lawyer skills." But it was an incident during Isaiah's junior year that solidified his path. He'd been walking home from a late basketball practice when a police car pulled up beside him. 2 officers emerged, demanding identification and explanation for his presence in Lincoln Park. Isaiah complied perfectly. He provided his student ID, explained he attended Lincoln Prep, and maintained calm despite the fear coursing through his system. "Lincoln Prep?" One officer, a man named Stevens, laughed. "Right. And I'm the mayor of Chicago." They searched his backpack without permission. They questioned him aggressively about drugs despite zero evidence. They detained him for 40 minutes on a cold November evening while they ran his information through multiple systems. Finally, they let him go with a warning to stay out of neighborhoods where he didn't belong. Isaiah arrived home shaking with anger and humiliation. Ruth held him while he cried tears of frustration at injustice he couldn't fight in that moment. "That's why you're going to be a lawyer," she said firmly. "So you can fight these fights with weapons they have to respect: education, credentials, the law itself." Isaiah threw himself into academics with renewed purpose. He graduated valedictorian from Lincoln Prep, earning admission to Northwestern University with a full scholarship. His acceptance letter arrived the same week his sister Alicia was accepted to Chicago State. Ruth cried tears of joy and exhaustion, knowing her sacrifices had produced results. Northwestern continued Isaiah's education in navigating predominantly white spaces. His freshman dormitory was filled with students whose parents were executives, politicians, and academics. Isaiah's mother cleaned buildings like the ones these students had grown up in. But Isaiah had learned adaptation. He joined debate team where his rhetorical skills flourished. He worked with the university's prison education program, tutoring incarcerated individuals pursuing degrees. He interned with the Cook County Public Defender's Office, witnessing firsthand how the criminal justice system processed poor defendants like assembly line products. Professor Elizabeth Morrison taught constitutional law during Isaiah's junior year. She was demanding, brilliant, and saw potential in Isaiah that transcended his background. "You understand the law intellectually," she told him after class one day, "but you also understand it viscerally from lived experience. That combination is rare and powerful." She encouraged Isaiah to apply to top law schools. He was admitted to Harvard, Yale, and Columbia. He chose Northwestern Law to stay close to his family and community. Law school was simultaneously the hardest and most affirming experience of Isaiah's life. The workload was crushing. Hundreds of pages of reading nightly, endless case preparation, the constant pressure of Socratic questioning in class. But for the first time, Isaiah was studying a system he could potentially change from within. Contract law, property law, criminal procedure, constitutional interpretation. These weren't abstract concepts. They were the frameworks that shaped daily life for people who looked like him. His law school advisor, Professor James Montgomery, was a black attorney who'd practiced civil rights law for 20 years before entering academia. "The law is a tool," Montgomery told Isaiah during their first meeting. "Like any tool, it can build or destroy. Your job is to figure out how to build." Isaiah excelled in law school, making law review and graduating in the top 10% of his class. Corporate firms offered him positions with six-figure starting salaries, but Isaiah had different plans. He joined the Cook County Public Defender's Office, earning a fraction of what his classmates made, but gaining invaluable trial experience. For 3 years, he defended clients who couldn't afford private attorneys, drug possession cases, assault charges, theft prosecutions. He learned courtroom dynamics, jury psychology, and how to cross-examine hostile witnesses. He learned which judges were fair and which carried biases. He learned that justice was less about truth and more about persuasion, preparation, and persistence. His most significant case during those years involved a teenager named Kevin Porter. Kevin was 17, accused of armed robbery based on eyewitness identification. The witness was certain, the prosecutor confident, the evidence circumstantial but compelling. Isaiah spent months investigating. He tracked down alibi witnesses, obtained security footage from multiple locations, and ultimately proved Kevin was across town when the robbery occurred. The eyewitness had been wrong, not malicious, just wrong. Kevin was acquitted. He went on to finish high school and enroll in community college. That case taught Isaiah that one person's diligence could change another person's entire life trajectory. After 3 years as a public defender, Isaiah opened his own practice focused on criminal defense and civil rights litigation. The first years were hard. Long hours, inconsistent income, the constant struggle to build a client base and reputation. But Isaiah had learned from watching his mother. Persistence overcame obstacles. He took cases other attorneys wouldn't touch. He represented clients who couldn't pay full fees. He built a reputation for thorough preparation and courtroom effectiveness. Word spread through Chicago's black communities. Bennett gets results. His practice grew. He won case after case, securing acquittals, dismissals, and favorable plea agreements. He successfully sued the Chicago Police Department 3 times for civil rights violations, winning substantial settlements for his clients. By his 10th year of practice, Isaiah had become one of Chicago's most respected criminal defense attorneys. His success rate was exceptional, his trial skills formidable, his commitment to justice unquestionable. He'd also maintained connections to Englewood. He offered free legal clinics at his childhood church, mentored young people from the neighborhood, and donated to Marcus Garvey Academy. Success for Isaiah meant lifting others while climbing. His sister Alicia had become a social worker, dedicating her career to family services. Their mother Ruth, now 62, had finally retired from her cleaning jobs, living comfortably in a small house Isaiah purchased for her. The Bennett family had risen from poverty to stability through relentless effort, strategic decisions, and unwavering belief in education as a pathway to change. But Isaiah never forgot where he came from or what he'd learned along the way. He never forgot Officer Stevens treating him like a criminal in Lincoln Park. He never forgot watching Marcus slammed against a police car at age 7. He never forgot the countless small indignities that came from existing in a black body in spaces where black bodies were presumed suspicious. Those experiences shaped every case he took, every client he represented, every argument he crafted. And on that Thursday morning in courtroom 4B, when Officer Kyle Brennan put hands on him without justification, Isaiah understood immediately what was happening and why. This wasn't about courtroom security. This was about power, presumption, and the refusal to see a black man as belonging in professional space. But Isaiah also understood something Brennan had miscalculated. This wasn't Englewood, where power imbalances meant Isaiah had no recourse. This wasn't a street corner where Brennan's badge meant absolute authority. This was a courtroom where law reigned supreme and Judge Sullivan was the ultimate authority. Brennan had assaulted an attorney in the one space where legal credentials mattered more than skin color, where professional standing carried weight, where actions had consequences that couldn't be ignored. Isaiah's entire life had prepared him for this moment. His mother's teachings about surviving injustice and fighting to change it. Mrs. Douglas recognizing his potential and opening doors. Daniel Blake mentoring him in professional conduct. Professor Morrison developing his legal analysis. Professor Montgomery teaching him to use law as a tool for justice. Every experience, every challenge, every triumph and setback had built the man who stood in courtroom 4B that morning and responded to assault with restraint and precision. Officer Brennan had no idea who he'd just put his hands on, but he was about to find out. The Cook County Jail intake facility smelled of industrial cleaner and desperation. Officer Kyle Brennan sat in a holding cell at 2:15 p.m. on Thursday afternoon, 3.5 hours after his arrest in courtroom 4B. The cell was designed to hold drunks, minor offenders, and people awaiting bond hearings. Now it held a Chicago police officer who'd crossed a line he didn't believe existed. Brennan's hands were free now, the handcuffs removed during processing, but the humiliation of being photographed, fingerprinted, and inventoried like a common criminal burned hotter than any physical restraint. His fellow officers had witnessed his arrest. Courthouse staff had watched him being led away in handcuffs. And worst of all, that attorney Isaiah Bennett had stood there calm and collected while Brennan's career imploded. Brennan's mind replayed the morning's events obsessively, searching for the moment where things went wrong. But in his narrative, he found no fault in his actions. He'd been doing his job, maintaining security, protecting the court from potential threats. That Bennett had approached too quickly, too confidently, with too much authority in his posture. Something about it triggered Brennan's instincts, his training, his understanding of how threats manifested. He'd responded appropriately. The problem wasn't his actions. The problem was Bennett's reaction and Judge Sullivan's failure to recognize legitimate security concerns. But Kyle Brennan's worldview had been shaped long before that Thursday morning. He'd grown up in Bridgeport, a historically white working-class neighborhood on Chicago's South Side. His father, Dennis Brennan, had been a police officer for 30 years. His grandfather, Patrick Brennan, had been a police officer before that. Law enforcement was the family business, the source of identity and pride. Being a cop meant something in the Brennan household. It meant respect, authority, and belonging to something bigger than yourself. Kyle's childhood home was filled with police memorabilia, badges, patches, photographs of 3 generations in uniform. Dinner table conversations revolved around shifts, arrests, and war stories from the street. A cop's job is to maintain order, Dennis told Kyle repeatedly throughout his childhood. Citizens might not always like it, but they need it. Without us, there's chaos. Dennis Brennan's policing philosophy was simple. Establish dominance, demand compliance, and never let anyone challenge your authority. Those principles had served him well during his career. He'd received commendations, promotions, and retired as a sergeant with full pension. He'd also accumulated 9 citizen complaints, including 2 allegations of excessive force. None were sustained. Internal affairs investigations found insufficient evidence, witnesses whose stories changed, and the benefit of doubt that officers routinely received. Kyle absorbed these lessons. He watched his father command respect through intimidation. He learned that backing down from confrontation meant weakness. He understood that the uniform granted authority that civilians had to respect. At 18, Kyle enrolled in the police academy immediately after high school graduation. He was following the path laid out for him since birth, fulfilling family expectation and personal ambition simultaneously. The academy reinforced Dennis's teachings. Training focused on officer safety, threat assessment, and command presence. Instructors emphasized that hesitation could be fatal, that citizens would test your authority, that showing weakness invited danger. Kyle graduated near the top of his academy class. He was physically fit, tactically proficient, and eager to prove himself worthy of the Brennan family legacy. His first assignment was patrol in District 5, covering parts of the South Side, including Englewood. The neighborhood's reputation preceded it: high crime rates, gang activity, poverty, and resistance to police presence. Kyle approached the assignment with the mindset his father had cultivated. These communities needed order imposed on them, not partnership developed with them. His first use of force incident occurred 6 months into his career. He'd responded to a noise complaint at a house party. The resident, a man named Terrence White, questioned whether police had the right to enter without a warrant. Kyle interpreted the question as challenge to his authority. The situation escalated rapidly. Kyle grabbed Terrence, forced him against a wall, and handcuffed him for disorderly conduct. Terrence filed a complaint. The investigation found Kyle's actions within policy guidelines. Questioning police authority could constitute disorderly conduct. Use of physical control to effectuate an arrest was authorized. Case closed. For Kyle, the message was clear. His instincts were correct, his actions justified, and complaints from communities like Englewood didn't threaten careers. Over 14 years, Kyle accumulated 12 citizen complaints. Each followed similar patterns: escalation of minor situations, use of force that witnesses described as excessive, and Kyle's consistent justification that citizens' behavior had required his response. 3 complaints were sustained after investigations found Kyle had violated department policies. He received suspensions without pay: 5 days for the first sustained finding, 10 days for the second, 15 days for the third. But suspensions weren't termination. Kyle returned to duty after each one, convinced that the system was too soft on officers, too willing to appease complainers who didn't understand the realities of street policing. His marriage to Nicole lasted 8 years before ending in divorce. She cited his anger, his inability to leave work at work, and his escalating belief that everyone was lying, challenging, or threatening. "You can't see people as human anymore," she told him during their final argument. "Everyone's either a cop or a suspect to you." Kyle dismissed her concerns. Civilians didn't understand police work. His fellow officers got it. That's what mattered. His closest friend on the force was Officer Ricky Palmer. They'd gone through the academy together and often worked overlapping shifts. Ricky shared Kyle's views about authority, respect, and the need to maintain control over challenging populations. Over beers after shifts, they'd trade stories about citizens who'd challenged them, judges who were too soft, and the political correctness that was supposedly destroying effective policing. "Used to be you could police without worrying about every little thing being filmed and complained about," Ricky would say. "Now everyone's got a phone and thinks they know our job better than we do." Kyle agreed completely. Body cameras, civilian oversight, and sensitivity training were obstacles to effective police work, not improvements to it. The internal investigation that led to his courtroom security assignment had stemmed from a traffic stop incident. Kyle had pulled over a driver for a broken tail light. The driver, a black man named Leonard Hughes, had informed Kyle he was recording the interaction on his phone. "Put that phone down," Kyle had ordered. "I have the right to record," Leonard responded calmly. The situation escalated. Kyle ordered Leonard out of the vehicle. Leonard complied but continued recording. Kyle grabbed the phone, triggering a physical altercation. Leonard ended up face down on the pavement with a lacerated forehead and a dislocated shoulder. The video was uploaded before Kyle could delete it. It showed Kyle initiating physical contact without clear justification. Leonard's attorney filed a federal civil rights lawsuit. The Chicago Police Department's Internal Affairs Division launched an investigation. Kyle was placed on desk duty pending the outcome. His assignment to courtroom security was supposed to be temporary, a way to keep him working while investigators reviewed his conduct. Kyle viewed the entire situation as political correctness run amok. He'd ordered a subject out of a vehicle during a lawful traffic stop. The subject had failed to fully comply. Kyle had used reasonable force to effectuate control. End of story. That the video showed something different, that witnesses described his actions as excessive, that Leonard required hospital treatment for injuries, none of that registered as evidence of wrongdoing in Kyle's mind. In the holding cell, Kyle's thoughts turned to Isaiah Bennett. The attorney had looked at him with those calm, controlled eyes. No fear, no deference, no acknowledgement of Kyle's authority, just quiet confidence that Kyle found deeply unsettling. In Kyle's experience, certain people responded to police authority in predictable ways. They became nervous, compliant, deferential. They understood the power dynamic and adjusted their behavior accordingly. Bennett hadn't done that. He'd stood there in his expensive suit with his leather briefcase, speaking in his educated voice, acting like he owned the courtroom. Something about it had triggered Kyle's deepest instincts about maintaining control and establishing dominance. Bennett needed to understand his place, needed to recognize that uniform meant authority, regardless of law degrees or fancy credentials. So Kyle had acted, in his mind. It was a reasonable response to a developing situation. Bennett was approaching the bench too quickly, too confidently. The movement could have been threatening. Kyle had intercepted and redirected, using appropriate force to establish control. That Judge Sullivan had interpreted his actions differently, that she'd arrested him for doing his job, that she'd humiliated him in front of civilians and colleagues, these were betrayals that Kyle couldn't reconcile with his worldview. The holding cell door opened. Sergeant Dennis Crawford appeared, his expression mixing concern and disappointment. Crawford was Kyle's immediate supervisor, the sergeant who'd authorized his courtroom security assignment. At 48, Crawford had been with the department for 22 years and had worked hard to develop a reputation as fair and professional. "Brennan," Crawford said quietly, "we need to talk." Kyle stood. "Sergeant, that judge is out of control. I was maintaining security and she arrested me for it. This is exactly what's wrong with the system. Judges don't understand police work." Crawford's expression hardened. "I've watched the security footage from the courtroom, all of it. You put your hands on an attorney who was performing routine courtroom functions. There was no security threat. There was no justification for physical contact. He was approaching too quickly. He was walking at a normal pace to submit a motion," Crawford interrupted. 12 other attorneys approached that bench the exact same way earlier in the morning. You didn't touch any of them. The implication hung between them. Kyle's face flushed. "This isn't about race. This is about security protocol and that attorney acting suspicious." "What was suspicious about his behavior, Officer Brennan? Be specific." Kyle opened his mouth, then closed it. How could he explain the instinct, the feeling, the sense that Bennett didn't belong in that space, approaching that bench with that level of confidence? "I'm on administrative leave effective immediately," Crawford said. "The superintendent has ordered a full investigation. The police board will review your conduct, and the state's attorney's office is considering additional charges beyond contempt of court." "Additional charges?" Kyle's voice rose. "For what? Doing my job?" "Assault, battery, deprivation of civil rights under color of law," Crawford listed. Take your pick. You committed all three on camera in front of multiple witnesses, including a sitting judge. The reality was beginning to penetrate Kyle's defensive wall. This wasn't going away. This was serious. Sergeant, I've got 14 years on the job. I've got commendations. My father served 30 years. My grandfather before that. This is my career. Then you should have thought about that before you put your hands on an attorney without cause, Crawford said without sympathy. The Fraternal Order of Police will provide you a union representative. You'll have due process. But Brennan, I'm going to be honest with you. This looks bad. Really bad. After Crawford left, Kyle sat in the holding cell and felt the foundations of his identity cracking. He was a police officer. That's who he was, what he'd always been, what his family had always been. The possibility that it could be taken away, that one moment in a courtroom could end generations of Brennan family tradition, was incomprehensible. His father, Dennis, arrived 2 hours later to post bond. The older Brennan's face was granite as he processed the paperwork and collected his son. They drove in silence through Chicago's late afternoon traffic. Finally, as they approached Bridgeport, Dennis spoke. "Tell me what happened, everything." Kyle explained his version of events. The attorney approaching the bench without permission, the security threat assessment, the reasonable use of force to maintain control, the judge's overreaction and abuse of authority. Dennis listened without interruption. When Kyle finished, the older man was quiet for several blocks. "Do you know who Isaiah Bennett is?" Dennis finally asked. "Some attorney," Kyle replied. "Probably an affirmative action hire who thinks his law degree makes him special." Dennis pulled the car over and turned to face his son. "Isaiah Bennett graduated valedictorian from Lincoln Prep, got a full scholarship to Northwestern, made law review, and has been practicing for 12 years. He's won civil rights cases against the department. He's respected by judges across Cook County, and you put your hands on him in a courtroom." Kyle stared at his father. "I didn't know all that." "It doesn't matter what you knew," Dennis said harshly. "What matters is you made assumptions based on how he looked, and you acted on those assumptions in the worst possible environment. Not a street corner where things can be explained away, a courtroom where everything is recorded and a judge is watching." "Dad, I was doing what you taught me. Establish authority. Don't back down. Maintain control." Dennis was silent for a long moment. When he spoke again, his voice carried something Kyle had never heard before. Doubt. "Maybe I taught you wrong. Maybe the world I policed in isn't the world you're policing in now. Maybe what worked for me doesn't work anymore." "What are you saying?" "I'm saying my career had complaints too, some sustained. But I always survived because the department protected its own. Things are different now. Body cameras, social media, judges who don't automatically side with officers. The rules have changed." Dennis restarted the car. "You need a good attorney, Kyle, not a union rep, a real attorney who specializes in defending cops. This is serious." That evening, Kyle sat in his apartment reviewing the day's events on his phone. The story had hit local news. Video from the courtroom security cameras had leaked, showing the entire confrontation. Kyle watched himself shove Isaiah Bennett. He saw Bennett stumble backward, papers scattering. He saw his own face, angry and self-righteous. He heard his own voice demanding Bennett back up, threatening arrest. And he saw Judge Sullivan's face as she ordered his arrest. The contempt in her expression was unmistakable. The news coverage wasn't sympathetic. Headlines ranged from objective to damning. "Officer arrested for assaulting attorney in court." "Chicago cop faces contempt charges after confrontation." "Judge orders arrest of officer who shoved black lawyer." That last headline made Kyle's blood pressure spike. This was being framed as racial. The media was making it about race when it was about security and respect for authority. Comments on news articles ran heavily against him. People who didn't understand police work, who'd never faced split-second decisions on the street, were judging his actions from comfortable positions of hindsight and distance. But some comments supported him. Fellow officers using anonymous accounts defended his actions. Civilians who believed in law and order praised him for maintaining security. Conservative commentators questioned whether judges had too much power to arrest officers. Kyle latched onto those supportive voices. They confirmed what he already believed. He'd done nothing wrong, and the system was punishing him for effective policing. His phone rang. Ricky Palmer, his closest friend on the force. "Man, I saw the news," Ricky said. "This is insane. You were doing your job and they arrested you for it." "I know," Kyle replied, relieved to hear validation. "These judges don't understand what we deal with. They sit up there in their robes making decisions without knowing what it's like on the street." "It's getting worse every year," Ricky agreed. "Cops can't do anything anymore without getting second-guessed. You're going to fight this, right?" "Absolutely. I've got union backing and my dad's helping me find a good attorney." This judge stepped way out of line. They talked for 40 minutes, reinforcing each other's belief that Kyle had been wronged, that the system had failed, that police were under attack from judges who didn't support law enforcement. When the call ended, Kyle felt better. His people understood. His fellow officers knew the truth. The union would protect him. But a small voice in the back of his mind, one he quickly suppressed, asked a question he didn't want to answer. If you did nothing wrong, why did everyone in that courtroom look at you with such shock and disapproval? Kyle pushed the question away. Doubt was weakness. Certainty was strength. He'd done his job. The rest was politics and perception. He didn't know that across the city, in a law office in the Loop, Isaiah Bennett was preparing a response that would transform this incident from personal confrontation to systemic reckoning. And he couldn't imagine that Judge Margaret Sullivan was drafting an opinion that would become required reading in judicial ethics courses nationwide. The battle lines were being drawn, but Kyle Brennan still believed he was on the right side of them. That belief was about to be thoroughly, publicly, and permanently challenged. Isaiah Bennett's law office occupied the 15th floor of a building on South Michigan Avenue. The space was modest but professional. A reception area, 2 conference rooms, offices for Isaiah and his 2 associate attorneys, and a small library lined with legal references. At 7:30 p.m. on Thursday evening, Isaiah sat in his office reviewing footage of the courtroom incident. His legal team had assembled, associates Diane Morrison and Jerome Franklin, and paralegal Tamara Russell. The video played on the conference room screen. They'd watched it 6 times already, analyzing every moment, every word, every facial expression. "The physical contact is clear," Diane said. She was 32, a former prosecutor who'd switched to defense work after becoming disillusioned with the state's attorney's office. "Brennan initiates without provocation. There's no arguable security justification." Jerome Franklin nodded. At 35, he'd been with Isaiah's firm for 4 years and specialized in civil rights litigation. "We've got assault, battery, and deprivation of rights under color of law. The federal claims are solid." Tamara Russell, who'd worked with Isaiah since he opened his practice, made notes on her tablet. "Media coverage is extensive and mostly favorable to us. Public sentiment is on our side." Isaiah rewound the video to the moment of contact. "What's our objective here? We could pursue criminal prosecution, civil litigation, or both, but what outcome serves justice?" It was the question that separated Isaiah from many attorneys. For him, legal strategy wasn't just about winning cases or maximizing damages. It was about achieving outcomes that changed systems and prevented future victims. Diane leaned forward. "Criminal prosecution sends a message that this behavior has consequences, but it's limited to Brennan individually. Civil litigation could target the Chicago Police Department's systemic failures in training and accountability. The department's pattern and practice is documentable," Jerome added. "Brennan has 12 complaints, 3 sustained findings. How many other officers have similar records? How is the department screening officers for courtroom assignments? What training exists to prevent this exact scenario?" Isaiah stood and walked to the window. Chicago's skyline glowed in the evening darkness. Somewhere out there, in neighborhoods like Englewood, Young people were being stopped, questioned, and subjected to the same assumptions that had led Brennan to put hands on him. We file a federal civil rights lawsuit against Brennan personally and the Chicago Police Department institutionally, Isaiah decided. We seek damages, but more importantly, we seek systemic reform. Court-ordered changes to training, screening, and accountability measures. Tamara looked up from her notes. That's going to be expensive and time-consuming. The city will fight hard. Let them fight, Isaiah replied. We have evidence, witnesses, and a judge who's already found probable cause for criminal contempt. Our case is strong. Over the next 3 hours, the team drafted the initial complaint. The document laid out not just Thursday's incident, but a comprehensive analysis of systemic failures that enabled officers like Brennan to repeatedly engage in discriminatory conduct without meaningful consequences. The complaint included statistical analysis showing racial disparities in police misconduct complaints, discipline rates, and courtroom security incidents. It detailed the department's inadequate training regarding implicit bias and appropriate use of force. It documented the protective culture that prioritized defending officers over addressing legitimate concerns. At 11:15 p.m., Isaiah sent the draft to Reverend Solomon Hayes, director of the Chicago Coalition for Justice. Solomon was 58, a veteran civil rights activist who'd worked on police reform for 3 decades. Solomon called back within 20 minutes. This is comprehensive, Solomon said. You're not just suing over one incident, you're challenging the whole system. That's the only way real change happens, Isaiah replied. Individual accountability is necessary but insufficient. We need structural reform. The department will argue that Brennan is an isolated bad actor, not representative of institutional problems. Which is why we're documenting patterns and practices. Brennan isn't an anomaly. He's a predictable result of inadequate systems. Solomon was quiet for a moment. Isaiah, you know this is going to put a target on your back. The Fraternal Order of Police doesn't take kindly to attorneys who sue the department. You'll face pushback, intimidation attempts, maybe worse. I know, Isaiah said calmly, but that's exactly why this lawsuit is necessary. If attorneys are afraid to challenge police misconduct, then accountability becomes impossible. All right, Solomon agreed. The coalition will provide public support. We'll mobilize community backing, organize press conferences, and document any retaliation attempts. After the call, Isaiah's team finalized the complaint. The lawsuit would be filed Friday morning in federal court, less than 24 hours after the courtroom incident. Meanwhile, across the city in a law office in River North, attorney Nathan Pierce reviewed the same courtroom footage. Pierce was 45, a specialist in defending police officers against misconduct allegations. The Fraternal Order of Police had retained him to represent Kyle Brennan. Pierce had defended dozens of officers over his 20-year career. He understood the dynamics, the optics, and the strategies that worked in these cases. But as he watched the video for the 4th time, Pierce recognized a significant problem. This case was indefensible on the merits. Brennan had initiated physical contact without justification. There was no security threat. The attorney had been performing routine courtroom functions. Judge Sullivan's reaction demonstrated how clearly inappropriate Brennan's conduct had been. Pierce's phone rang. The caller ID showed Dennis Brennan, Kyle's father. Mr. Pierce, this is Dennis Brennan. The union gave me your name. Can you help my son? Mr. Brennan, I've reviewed the footage. I'm going to be honest with you. This is a difficult case. Your son's actions are clearly documented, and a judge has already found them worthy of arrest. But he was doing his job, Dennis protested. He was maintaining security. I understand that's his perception, Pierce said carefully. But courtroom security doesn't authorize officers to physically contact attorneys who are performing appropriate functions. Every judge in Cook County will testify that defense counsel routinely approaches the bench to submit motions. Your son's response was disproportionate. So what are you saying? He should just accept whatever punishment they throw at him? I'm saying we need to focus on mitigation rather than justification. Arguing that your son did nothing wrong is a losing strategy. The evidence contradicts that narrative completely. Pierce heard Dennis Brennan's frustrated exhale through the phone. What's mitigation look like? Acknowledging the mistake, expressing genuine remorse, agreeing to retraining and counseling, and accepting reasonable discipline. If we can demonstrate your son understands what he did wrong and is committed to change, we might avoid criminal prosecution beyond the contempt charge. My son doesn't think he did anything wrong, Dennis said. He thinks this is political correctness and judicial overreach. Pierce closed his eyes. This was the problem he encountered frequently. Officers so convinced of their own righteousness that they couldn't recognize clear misconduct. Mr. Brennan, I need to speak with your son directly. If he's not willing to acknowledge any wrongdoing, then his options become very limited. And I should tell you, there's likely going to be a civil rights lawsuit. That attorney has every right to sue, and the case will be expensive for your son personally if he's found liable. After the call ended, Pierce sat in his office contemplating the challenges ahead. Defending the indefensible required creativity and strategy, but it also required a client willing to accept reality. He suspected Kyle Brennan wasn't there yet. Friday morning arrived with media coverage dominating Chicago's news cycle. The story had expanded beyond local interest to national attention. Video of the courtroom confrontation circulated on social media platforms, generating millions of views and thousands of heated comments. At 9 a.m., Isaiah and his legal team entered the Everett Dirksen Federal Building to file their lawsuit. A crowd of reporters waited on the plaza outside. Jessica Holloway from the Chicago Tribune approached first. Mr. Bennett, can you comment on the lawsuit you're filing today? Isaiah had prepared his statement carefully. We're filing a federal civil rights lawsuit against Officer Kyle Brennan and the Chicago Police Department. This case is about more than one incident. It's about systematic failures that allow discriminatory conduct to persist without meaningful accountability. What are you seeking? Another reporter called out. Justice for what happened to me, but more importantly, reform that prevents this from happening to others. We're seeking damages, but also court-ordered changes to training, screening, and discipline procedures. How do you respond to people who say you're overreacting? Asked a reporter from a conservative news outlet. Isaiah looked directly at the camera. I'm a licensed attorney who was physically assaulted while performing routine courtroom duties. If that happened to a white attorney, we wouldn't be having this conversation because the incident wouldn't have occurred. The fact that some people think my response is excessive proves exactly why reform is necessary. The filing itself took 15 minutes. The complaint ran 47 pages, meticulously documenting every aspect of the case. Within an hour, it was public record and being analyzed by legal experts across the country. Judge Sullivan had spent Thursday evening drafting her written opinion, explaining why she'd held Brennan in contempt. The document was filed Friday morning and immediately became required reading for anyone following the case. Her opinion was devastating in its clarity. Officer Brennan's conduct in this courtroom constituted a clear and egregious violation of basic courtroom protocol and professional courtesy. His physical assault on defense counsel occurred without justification or provocation. This court has presided over thousands of proceedings in which attorneys approach the bench to submit motions. Never before has any security officer interpreted such routine conduct as threatening. She continued, the court cannot ignore the obvious implication that Officer Brennan's perception of threat correlated more closely with defense counsel's race than with counsel's actual behavior. When law enforcement officers allow implicit bias to drive their actions, particularly in judicial settings where equal treatment before the law is paramount, such conduct undermines the very foundations of our justice system. The opinion concluded, this court has zero tolerance for discriminatory conduct within its jurisdiction. Officer Brennan's assault on an officer of this court warranted immediate intervention. His subsequent failure to acknowledge any wrongdoing demonstrates a troubling lack of judgment that calls into serious question his fitness to serve in any law enforcement capacity. The opinion was widely praised by legal scholars and civil rights advocates. Several judges from other jurisdictions issued statements supporting Judge Sullivan's decisive action. But the Fraternal Order of Police saw things differently. At 2:01 p.m. Friday, FOP President Calvin Jennings held a press conference. Jennings was 52, a 28-year veteran of the Chicago Police Department and a fierce defender of officer rights. Officer Kyle Brennan is a dedicated public servant with 14 years of exemplary service. Jennings began. He was performing his assigned duties when he made a split-second decision to maintain courtroom security. For a judge to arrest an officer for doing his job sets a dangerous precedent that will make every cop hesitate when faced with potential threats. Reporters immediately challenged the narrative. The attorney was submitting a routine motion, one pointed out. What threat did that pose? Jennings didn't waver. Officers are trained to identify and respond to potentially threatening situations. We weren't there. We don't know what Officer Brennan observed that triggered his security assessment. Monday morning quarterbacking from people who've never worn the uniform doesn't help anyone. The video shows the attorney walking normally and calmly, another reporter pressed. Where's the threat? Body language can be deceptive. Officer Brennan has training and experience in threat assessment that civilians lack. We trust our officers to make these judgment calls, and we support them when they act to maintain safety. The press conference generated its own round of coverage and controversy. Public opinion divided along predictable lines, those who believed police could do no wrong versus those who saw clear discrimination. But in the middle were many people who simply watched the video and reached their own conclusions. What they saw was an attorney walking normally being shoved for no apparent reason. The explanation that sophisticated threat assessment justified the response didn't match what their eyes showed them. By Friday evening, the story had reached national cable news. Legal analysts debated on CNN, MSNBC, and Fox News. Civil rights advocates and police union representatives argued on talk shows. Social media erupted with opinions, arguments, and increasingly heated exchanges. Isaiah's phone rang constantly. Interview requests, messages of support, threats from people who saw him as attacking police, and offers of assistance from attorneys across the country who'd handled similar cases. His mother Ruth called Friday night. "Baby, I'm proud of you for standing up, but I'm also worried. These are powerful people you're challenging." "Mom, remember what you taught me? Be smart enough to survive it and strong enough to change it. That's what I'm doing." "I know, sweetheart. Just be careful. Justice is important, but so is your safety." After they hung up, Isaiah stood at his office window, looking out at Chicago's lights. The city continued its Friday night rhythm, indifferent to the legal and social battle beginning to unfold. Somewhere out there, Kyle Brennan was likely watching the same news coverage, reading the same social media posts, and processing the reality that his career and reputation hung in the balance. Isaiah felt no satisfaction in that. This wasn't about destroying one officer. It was about changing systems that enabled discriminatory conduct to persist generation after generation. But changing systems required battles that were long, expensive, and emotionally exhausting. Isaiah had fought these battles before. He'd won some and lost others. Each one took something from him, even the victories. Yet he continued fighting because the alternative was accepting injustice as inevitable. His phone buzzed with a text from Diane Morrison. "Just saw FOP press conference. They're going hard at defending Brennan. This is going to be a war." Isaiah typed his response. "Let it be a war then. We've got truth on our side." He knew that truth alone didn't guarantee victory, but it was a foundation strong enough to build on. And sometimes that had to be enough. The weekend would bring more developments, more controversy, and more positioning by both sides. But the basic battle lines were drawn. Accountability versus protection. systemic reform versus status quo, and the fundamental question of whether one moment of injustice could catalyze meaningful change. Isaiah was determined that it would. The question was whether the institutions involved were ready for the transformation he was demanding. Time would tell. But Isaiah Bennett wasn't going anywhere. He'd spent his entire life preparing for fights exactly like this one, and he intended to win. Monday morning brought Isaiah Bennett back to his office at 6:30 a.m. His legal team had worked through the weekend compiling evidence, researching precedents, and building the comprehensive case against both Kyle Brennan and the Chicago Police Department. The conference room table was covered with documents, internal affairs reports, citizen complaints, training records, and policy manuals. Diane Morrison had organized everything into color-coded categories that told a damning story about systemic failures. Kyle Brennan isn't the only problem, Diane said as the team assembled. We've identified 23 other officers with similar complaint patterns who remain on active duty. The department's discipline system is broken. Jerome Franklin pulled up a presentation on the screen. Here's what we found about Brennan's courtroom assignment. Despite having an active internal affairs investigation and 3 sustained findings of excessive force on his record, he was assigned to courtroom security without additional screening or training. Who made that assignment decision? Isaiah asked. Sergeant Dennis Crawford. But Crawford followed standard department protocol. There is no enhanced screening process for courtroom assignments. Any officer in good standing, meaning not currently suspended, can be assigned. Isaiah made notes. So, an officer with multiple excessive force findings and an active investigation is considered in good standing. According to department definitions, yes. Good standing only excludes officers currently under suspension or criminal indictment. Tamara Russell interjected. I've been going through courtroom security incident reports for the past 5 years. Guess how many times officers have had physical contact with attorneys? Thursday's incident makes 1, Isaiah said. Wrong. 7 times, but the other 6 involved attorneys who filed complaints that were either dismissed or resolved through quiet internal discipline. None resulted in criminal charges or public accountability. She pulled up the reports. Every incident involved Black or Latino attorneys. The pattern was unmistakable. This is our case, Isaiah said. Individual accountability for Brennan, but institutional accountability for the Chicago Police Department. They created the conditions that made Thursday's incident inevitable. At the same time, Kyle Brennan sat across from attorney Nathan Pierce in a conference room in River North. Pierce had Kyle's complete personnel files spread before them. I need you to be honest with me, Pierce began. Have you read through your complaint history? Kyle shifted uncomfortably. I've dealt with complaints before. Comes with the job. Citizens don't understand police work, so they complain when we do what's necessary. That's not what I asked. Have you read through the specific allegations, the investigation findings, and the patterns that emerge? I know what they say, Kyle replied defensively, but context matters. Those investigations don't show the full picture of what happened in each situation. Pierce opened the first file. Mrs. Eleanor Hayes, age 64, complained that you threw her against a car during a traffic stop. She had a clean record, was pulled over for a broken taillight, and asked to see your supervisor. The investigation found you used unnecessary force. She was being confrontational and non-compliant, Kyle said immediately. She asked to see your supervisor, that's her right. The tone matters, how she asked, whether she was trying to undermine my authority. Pierce moved to the next file. Terrence White, house party noise complaint. You arrested him for disorderly conduct after he questioned whether you had the right to enter his home without a warrant. The investigation sustained the excessive force finding. What's your explanation? He was obstructing a lawful investigation and challenging my authority. I had to establish control of the situation. By slamming him against a wall? By using appropriate force to effectuate an arrest. Pierce continued through 7 more complaints. With each one, Kyle's explanations revolved around themes of respect, authority, control, and compliance. Citizens who questioned him, who didn't immediately defer to his commands, who asserted their rights, all were described as confrontational, suspicious, or threatening. "Do you see the pattern?" Pierce finally asked. "The pattern is that I work in difficult neighborhoods with people who don't respect law enforcement," Kyle replied. "That's the reality of policing those communities." Pierce leaned back in his chair. This was the moment where he had to deliver uncomfortable truth. "Kyle, I've been defending police officers for 20 years. I understand the challenges of the job. I've represented good cops who made mistakes in difficult situations. But I'm going to be direct with you. Your problem isn't bad luck or difficult assignments. Your problem is that you escalate situations that don't need escalation." Kyle's face reddened. "I respond appropriately to the threats I encounter." "No. You respond to perceived disrespect with force. There's a difference. When a 64-year-old woman asks to speak with your supervisor, that's not a threat. When someone questions whether you can enter their home without a warrant, that's not obstruction. When an attorney approaches a bench to submit a motion, that's not aggression. So I'm supposed to just let people challenge me, let them think they can tell me what to do?" "Yes," Pierce said firmly. "If someone's not breaking the law, not threatening safety, and just exercising their rights or questioning your actions, you're supposed to let them. You're a public servant, not a king. Citizens have rights even when they make your job harder." Kyle stood abruptly. "I don't need a lecture about police work from someone who's never worn the uniform." "Then you need a different attorney," Pierce replied calmly. "Because my strategy requires you to acknowledge that Thursday's incident was a mistake. If you can't do that, I can't effectively defend you." They stared at each other across the conference table. Finally, Kyle sat back down. "What happens if I don't acknowledge wrongdoing?" "You face criminal prosecution beyond contempt, possible federal civil rights charges, a civil lawsuit that you'll lose, termination from the police department, and permanent unemployability in law enforcement. Your pension could be at risk. Your reputation will be destroyed, and you'll be alone because the union can't protect officers who refuse to take responsibility." The reality landed hard. Kyle had expected his attorney to provide aggressive defense, to challenge the narrative, to prove he'd done nothing wrong. Instead, Pierce was demanding surrender. "I need time to think," Kyle said. "You have until Wednesday," Pierce replied. "The preliminary hearing on the contempt charge is Thursday morning. I need to know whether you're willing to accept responsibility so I can negotiate with prosecutors. If not, we go to trial and almost certainly lose." After Kyle left, Pierce called Dennis Brennan. "Your son is in serious denial about the situation. He's convinced he did nothing wrong and that everyone else is overreacting." "That's what I taught him," Dennis admitted. "Never back down, never admit fault, always project strength. Those principles might work on the street, but they don't work in courtrooms. Judges and juries see through it. Your son needs to accept reality or he's going to lose everything." Dennis was quiet. "What would you have him do?" "Plead guilty to contempt, accept whatever discipline Judge Sullivan imposes, agree to counseling and retraining, express genuine remorse, and settle the civil case with an admission that his conduct was inappropriate. It's a bitter pill, but it's survivable." "And if he fights?" "He loses, badly and publicly. The video doesn't lie, Mr. Brennan. Your son assaulted an attorney in a courtroom. No amount of spin changes that." That afternoon, the Chicago Police Department's Office of the Superintendent issued a statement. Superintendent Thomas Riley had been in the position for 18 months, brought in specifically to reform the department after a series of scandals. Riley was 55, former chief of police in Seattle, with a reputation for accountability and transparency. His statement reflected those values. "The incident involving Officer Kyle Brennan is under comprehensive investigation. While Officer Brennan is entitled to due process, I want to be clear that the behavior captured on video does not represent the standards we expect from Chicago Police Department personnel. We are reviewing not only Officer Brennan's conduct, but also the policies and procedures that allowed an officer with his complaint history to be assigned to courtroom security without enhanced screening. Reforms will be implemented based on the findings of this investigation. The statement angered the Fraternal Order of Police, but reassured community advocates who'd long criticized the department's protective culture. Calvin Jennings, the FOP president, responded immediately. Superintendent Riley is throwing Officer Brennan under the bus to appease critics of law enforcement. This rush to judgment without full investigation undermines every officer's confidence that their department will support them in difficult situations. The battle lines were hardening. But behind the public statements, negotiations were beginning. Wednesday afternoon, Nathan Pierce met with Assistant State's Attorney Richard Lawson and Isaiah Bennett at the State's Attorney's office. These were preliminary discussions, feeling out whether resolution was possible before Thursday's hearing. "My client is willing to plead guilty to contempt," Pierce began. He acknowledges that his response to Mr. Bennett was inappropriate and that he exercised poor judgment. Isaiah raised an eyebrow. That's a significant shift from his initial position. He's had time to reflect and review the evidence. He understands the gravity of the situation. Isaiah leaned forward. "I need to hear this directly from your client. If Officer Brennan is genuinely accepting responsibility, I want to see that it's authentic rather than strategic." "That can be arranged," Pierce agreed. "But I need assurances that you're open to settlement discussions. My client needs to know that accepting responsibility won't result in unlimited consequences." "The consequences need to match the harm," Isaiah replied. "Officer Brennan assaulted me, disrupted court proceedings, and demonstrated bias that almost certainly has affected his policing for years. A simple apology and some training isn't sufficient." "What are you seeking?" Lawson asked. Isaiah had prepared for this question. In the criminal case, guilty plea to contempt with appropriate punishment determined by Judge Sullivan. In the civil case, admission of wrongdoing, substantial damages including punitive damages, and Officer Brennan's agreement to permanently separate from law enforcement. Additionally, a consent decree requiring the Chicago Police Department to implement comprehensive reforms regarding officer screening, training, and discipline. Pierce's expression showed surprise. Permanent separation from law enforcement? That's his entire career, his family legacy, his identity. And my dignity, my safety, and my civil rights are what his conduct violated, Isaiah countered. If Officer Brennan can't perform his duties without assaulting people based on racial assumptions, then he shouldn't be performing those duties. The consent decree requirements would need to be negotiated with the city's corporation council, Lawson noted. That's beyond my authority. I understand, but any settlement package needs to address systemic issues, not just this incident. The meeting ended without resolution, but with understanding that negotiations would continue. Pierce left to brief Kyle on the discussions and the reality that keeping his career would be nearly impossible. Thursday morning arrived with courtroom 4B packed to capacity. Spectators filled every seat, reporters crowded the press area, and courthouse staff who normally worked elsewhere found reasons to be present. Judge Margaret Sullivan entered promptly at 9 a.m. The bailiff called the courtroom to order, and everyone stood. Kyle Brennan sat at the defense table beside Nathan Pierce. He wore a dark suit instead of his uniform, looking diminished without the badge and authority that had defined him for 14 years. Isaiah sat in the gallery, present as both victim and observer. Judge Sullivan had invited him to attend, but made clear his presence was optional. "The matter before this court," Judge Sullivan began, "is the criminal contempt charge against Officer Kyle Brennan stemming from his conduct in this courtroom on Thursday of last week. Mr. Pierce, how does your client plead?" Pierce stood. "Your Honor, my client pleads guilty to criminal contempt of court." A murmur ran through the courtroom. Guilty pleas were rare in these proceedings. Most officers fought charges to the end, relying on union support and the department's protective culture. "Mr. Brennan," Judge Sullivan addressed Kyle directly, You understand that by pleading guilty, you're admitting that you disrupted court proceedings and assaulted an attorney while that attorney was performing routine courtroom functions? Kyle stood slowly. His face showed the struggle between pride and pragmatism. Yes, Your Honor. Do you have anything you'd like to say before I impose sentence? This was the moment Nathan Pierce had prepared Kyle for. The attorney had drilled his client on the importance of genuine remorse, of acknowledging harm rather than making excuses. Kyle took a breath. Your Honor, I want to apologize to Mr. Bennett and to this court. My actions were inappropriate and unprofessional. I let my assumptions override my judgment, and I caused harm to someone who deserved respect, not aggression. The words sounded rehearsed, but they were words Kyle had never spoken before in his career. Admitting fault went against every instinct his father had cultivated, every principle the police culture had reinforced. Judge Sullivan studied Kyle for a long moment. Mr. Brennan, I've read your personnel file. You have 12 citizen complaints, 3 sustained findings of excessive force, and a pattern of escalating minor situations into confrontations. Your conduct in this courtroom last Thursday was not an aberration. It was the predictable result of years of uncorrected behavior. She paused, letting the assessment sink in. However, I also recognize that you are here today accepting responsibility, something rare and difficult for anyone, particularly in police culture. That demonstrates at least the possibility of growth. Judge Sullivan outlined her sentence. 30 days in jail, suspended pending successful completion of 200 hours of community service, mandatory bias awareness training, anger management counseling, and a written apology to Isaiah to be filed with the court. Additionally, she continued, I am recommending to the Chicago Police Department that you be separated from service. Your pattern of conduct demonstrates unfitness for the authority that law enforcement carries. You may be a good person capable of positive contribution to society, but being a police officer requires judgment and restraint you have repeatedly failed to demonstrate. Kyle's face remained neutral, but his hands gripped the table's edge. His career was over. The Brennan family legacy in law enforcement ended with him. After the hearing concluded, Isaiah waited in the hallway. Kyle emerged with Nathan Pierce, and their eyes met for the first time since the confrontation. Pierce spoke first. Mr. Bennett, my client would like to speak with you if you're willing. Isaiah nodded. They moved to a quiet corner away from reporters and spectators. Kyle struggled to find words. Finally, he said, Mr. Bennett, I know my apology in there sounded hollow. Maybe it was. I've spent my whole life believing I was on the right side of things, doing necessary work, maintaining order. It's hard to accept that I've been wrong about fundamental aspects of how I viewed my job and the people I interacted with. Isaiah remained silent, letting Kyle continue. I don't know if I was racist. I never thought of myself that way. But watching that video, seeing how I reacted to you compared to how I treated white attorneys earlier that same morning, I can't deny the different treatment. Something in my thinking, my instincts, my assumptions was wrong. Kyle's voice cracked slightly. You were just doing your job. You're more educated, more accomplished, more successful than I'll ever be. And I put my hands on you because of how you looked, not because of what you did. That's inexcusable. Isaiah considered his response carefully. This moment mattered not just for Kyle's personal growth, but for the broader conversation about accountability and change. Officer Brennan, racism isn't always conscious hatred. Often it's unconscious bias, assumptions we don't even recognize we're making. The system you worked in reinforced those assumptions, rewarded aggressive responses, and protected you from consequences. Your individual responsibility is real, but so is the institutional responsibility. He paused. I accept your apology. But apologies without changed behavior are meaningless. You're losing your career, and that's appropriate given your record. The question is who you become next. Kyle nodded. My attorney says you want me permanently separated from law enforcement. I understand why. I'm not fighting it anymore. After Kyle and Pierce departed, reporters surrounded Isaiah seeking comment. He kept his statement brief. Justice was served today, but individual accountability is only the first step. Systemic reform remains necessary to prevent future incidents. Over the following weeks, negotiations continued regarding the civil lawsuit and consent decree. The city of Chicago initially resisted comprehensive reforms, arguing that Brennan was an isolated case not indicative of broader problems. Isaiah's legal team responded by documenting patterns across the department: racial disparities in use of force, inadequate discipline for officers with multiple complaints, and lack of screening for assignments requiring interaction with attorneys and judges. Deputy Chief Jerome Franklin of the Chicago Police Department became an unexpected ally in the reform process. Franklin was 51, a 28-year veteran who'd risen through the ranks while maintaining reputation for fairness and integrity. He'd watched the Brennan incident with dismay, recognizing it as symptom of larger cultural problems. Franklin reached out to Isaiah through back channels, offering to provide internal perspective on where reforms would be most effective and which institutional barriers needed addressing. "The department has good officers who want to do right," Franklin told Isaiah during a private meeting. "But the culture protects bad actors and punishes those who speak up about problems. If you can force structural changes through the consent decree, you'll help the good cops more than hurt them." Franklin's insider knowledge proved invaluable. He identified specific policy failures, training gaps, and accountability mechanisms that existed on paper but weren't enforced in practice. The negotiations extended through February and into March. Media attention remained high as each development was reported, analyzed, and debated across national platforms. Reverend Solomon Hayes organized community forums where citizens shared their own experiences with police misconduct. The stories were numerous and consistent: escalation of minor situations, assumption of criminality based on appearance, and lack of accountability when complaints were filed. These forums were documented and submitted as evidence in the civil lawsuit, demonstrating that Brennan's conduct reflected broader patterns affecting communities across Chicago. By mid-March, pressure on the city had intensified. The federal judge overseeing the civil case, Judge Elizabeth Warren, indicated that if settlement couldn't be reached, she was prepared to allow the case to proceed with expanded scope, examining department-wide practices. The city's corporation counsel, Harold Green, finally acknowledged reality. Fighting would be more expensive and damaging than settling with reforms. The final settlement agreement was announced on March 28th. The terms were comprehensive. Kyle Brennan agreed to permanent separation from law enforcement anywhere in the United States, payment of substantial damages to Isaiah, and participation in a documentary about implicit bias in policing. The Chicago Police Department agreed to a 5-year consent decree requiring enhanced screening for officer assignments, mandatory bias training every 6 months, independent oversight of complaint investigations, public reporting of discipline decisions, and creation of a community advisory board with authority to review policies. The financial settlement included damages to Isaiah and funding for community programs addressing police-community relations. Most significantly, the consent decree would be enforced by the federal court with regular monitoring and potential sanctions for non-compliance. At the press conference announcing the settlement, Isaiah stood beside Reverend Hayes, Diane Morrison, Jerome Franklin, and Deputy Chief Franklin, who'd been promoted to lead the department's reform implementation. "This settlement represents what accountability looks like," Isaiah began. "Individual consequences for individual misconduct and systemic reforms to prevent future harm. Officer Brennan will face the consequences of his actions, but more importantly, the institution that enabled his conduct for 14 years will be transformed." He continued, "This is not about punishing good police officers. It's about creating systems that support and reward good policing while identifying and addressing problematic conduct before it escalates. The officers who've always done the right thing have nothing to fear from these reforms." Reporter Jessica Holloway, who'd covered the story from the beginning, asked the question many were thinking. "Mr. Bennett, do you believe this settlement will actually change police culture, or is it just words on paper? The consent decree has enforcement mechanisms, Isaiah replied. Federal court oversight, independent monitoring, and public reporting create accountability that's been lacking. Will it solve every problem? No. But it creates infrastructure for ongoing improvement, and that's significant progress. Calvin Jennings from the Fraternal Order of Police gave a statement expressing disappointment that the city had capitulated to pressure rather than supporting its officers. But his words carried less weight now. The evidence had been too clear, the pattern too obvious, and the outcome too justified for the usual defenses to gain traction. September brought cooler temperatures to Chicago and the first measurable results from the consent decree reforms. Isaiah stood in the same marble lobby of the Cook County Criminal Courthouse where the confrontation had occurred 6 months earlier. The building looked the same, but protocols had changed significantly. All courtroom security officers now wore body cameras that activated automatically upon entering courtrooms. A new screening process evaluated officers' complaint histories and required specialized training before courtroom assignments. Most significantly, a civilian court liaison position had been created to monitor interactions between security personnel and attorneys, with authority to immediately address inappropriate conduct. Isaiah was there for a hearing in a different case, but Judge Sullivan had requested he stop by her chambers afterward. "Mr. Bennett," Judge Sullivan greeted him warmly when he arrived. "Thank you for coming. I wanted to update you on the implementation of reforms in our courthouse." She shared statistics that told an encouraging story. Since the new protocols were implemented, there had been 0 physical contact incidents between security officers and attorneys. Complaints about disrespectful treatment had decreased by 73%, and officer satisfaction with their assignments had actually increased because clear guidelines eliminated ambiguity. "The officers appreciate knowing exactly what's expected," Judge Sullivan explained. "The good ones always did the right thing anyway. The reforms just made it impossible for the bad ones to hide." She paused. "I also wanted to tell you that your case is being taught in judicial training programs nationwide. What happened in my courtroom became a teaching moment about recognizing and addressing bias in legal settings." Isaiah felt satisfaction mixed with exhaustion. The victory was real, but it had required 6 months of intense legal work, public scrutiny, and emotional toll. "How are you doing personally?" Judge Sullivan asked with genuine concern. "I'm all right," Isaiah replied. "Some days I think about what could have happened if you hadn't intervened, if Brennan had escalated further, if I'd responded with anger instead of restraint. The what-ifs can be overwhelming. But you did respond with restraint, and the system worked the way it should. That's worth remembering." Isaiah visited his mother Ruth that evening. She was 62 now, retired and living comfortably in the house Isaiah had purchased. His sister Alicia was there with her 2 children, Isaiah's nieces, who were 7 and 9. The girls asked Uncle Isaiah to explain what had happened in the courthouse. They'd heard parts of the story but wanted to understand it better. Isaiah sat with them on the living room floor. "Sometimes people make assumptions about other people based on how they look rather than who they are. A police officer made assumptions about me and treated me badly because of those assumptions." "Because you're black?" the 9-year-old asked directly. "Yes, probably. He saw my skin color and made judgments that weren't fair or accurate." "What did you do?" "I stayed calm, documented what happened, and used the law to hold him accountable. I showed that being treated unfairly doesn't mean you have to respond with anger. Sometimes the most powerful response is using the tools society gives us, like courts and laws, to create change." Ruth watched the conversation with pride. Her son was teaching the next generation the same lessons she'd taught him. Survive injustice with intelligence, fight it with strategy, and never accept that things can't change. Kyle Brennan's life had taken a different trajectory. He'd completed his community service working at a youth center on the South Side, teaching conflict resolution and anger management to teenagers who reminded him uncomfortably of younger versions of people he'd arrested. The experience was humbling. These kids lived with challenges Kyle had never faced. poverty, violence in their neighborhoods, inadequate schools, and constant surveillance by police who assumed criminality based on zip codes. His mandatory counseling had forced confrontation with beliefs he'd never examined. His therapist, Dr. Helena Cross, was a black woman with 20 years of experience working with law enforcement personnel. "You were taught that authority means demanding compliance," Dr. Cross explained during one session, "but real authority comes from respect earned, not fear imposed. You confused the two for your entire career." Kyle had initially resisted her analysis, but as weeks became months, the evidence of his own life made denial impossible. Every sustained complaint, every escalated situation, every moment where he'd chosen aggression over de-escalation told the same story. He'd been wrong, fundamentally, persistently, damagingly wrong about how to be a police officer. The documentary he'd agreed to participate in was being produced by an independent filmmaker named Alicia Torres. She approached the project with nuance, exploring not just Kyle's individual story, but the institutional and cultural factors that had shaped his behavior. During filming, Kyle was asked what he'd say to Isaiah Bennett if given the opportunity. "I'd tell him I'm sorry, truly sorry, not just for what happened in the courtroom, but for every person I treated the way I treated him throughout my career. People whose names I don't even remember, who I assumed were threats or criminals based on prejudice I didn't recognize I had." Kyle's voice was heavy with regret. "I can't undo the harm I caused. I can't give back the dignity I took from people. All I can do is be honest about my failures and hope that honesty helps someone else recognize their own biases before they cause similar harm." The documentary would premiere the following spring and generate its own conversations about police culture, accountability, and the possibility of redemption. But Kyle understood that redemption, if it came, would be measured not by his own feelings, but by whether his changed behavior prevented future harm. He'd enrolled in classes at community college, studying social work. The career change was radical, but Kyle was discovering that the skills he'd developed as a police officer, the ability to assess situations quickly and interact with people under stress, could be channeled toward helping rather than controlling. His father, Dennis, watched the transformation with mixed emotions: pride that Kyle was taking responsibility, sadness that generations of family tradition in law enforcement had ended, and growing recognition that perhaps he'd taught his son principles that looked different in practice than they had in theory. "I'm sorry I taught you that backing down was weakness," Dennis told Kyle during a difficult conversation in October. "I'm sorry I modeled that domination was the path to respect. I was wrong about a lot of things." The admission cost Dennis something. His identity was wrapped up in his career, his beliefs about policing, and his pride in the Brennan family legacy. Acknowledging that the legacy had included harm required confronting uncomfortable truths about his own career. Meanwhile, the consent decree was producing measurable results across the Chicago Police Department. Deputy Chief Franklin led the implementation with determination to prove that reforms could improve rather than hinder effective policing. Statistical analysis after 6 months showed promising trends. Use of force incidents had decreased 31% overall and 47% in encounters that began with minor infractions. Citizen complaints were down 28%, and perhaps most surprisingly, officer injuries during confrontations had decreased 19%. Franklin presented these results during a community forum in November. The data shows what many of us already knew. De-escalation is safer for everyone, including officers. When we train officers to see people as human beings, deserving respect rather than potential threats requiring control, outcomes improve. He continued, "This doesn't mean the job is easy or that dangers don't exist, but it means we can do this job effectively while treating people with dignity. Those aren't competing values, they're complementary ones. Not everyone was convinced. Some officers remained hostile to the reforms, viewing them as political correctness that endangered officer safety. The FOP continued raising concerns about oversight and accountability mechanisms, but the center was shifting. More officers were embracing the training, recognizing that it provided tools for navigating complex situations more effectively. The cultural change was slow, but it was happening. Isaiah was invited to speak at Northwestern Law School in December. The auditorium was packed with students eager to hear from the attorney whose case had sparked national conversations about justice, accountability, and reform. The courtroom confrontation lasted about 5 minutes, Isaiah told the students, but the work that followed lasted 6 months and isn't finished yet. Real change is slow, difficult, and requires persistence that extends far beyond initial victories. A student raised her hand. Mr. Bennett, some people criticized you for pushing for Officer Brennan's termination rather than just accepting an apology. How do you respond to that? Isaiah considered the question carefully. Accountability requires consequences proportionate to harm. Officer Brennan had 14 years of documented problems that the system failed to address. Allowing him to remain in law enforcement with just an apology would have guaranteed future victims. Sometimes compassion means protecting others from someone who's demonstrated inability to perform their duties safely. Another student asked, "Do you think Officer Brennan deserves a chance at redemption?" "Redemption isn't something anyone else can grant," Isaiah replied. "It's something you earn through changed behavior over time." Officer Brennan lost his career because his conduct warranted that consequence. Whether he finds redemption depends on what he does with the rest of his life. I hope he does, because I believe people can change, but hoping for someone's growth doesn't mean protecting them from consequences. The event concluded with a standing ovation, but Isaiah felt the weight of representation. His case had become symbolic of larger struggles carrying expectations and meanings beyond his individual experience. Professor Elizabeth Morrison, who'd encouraged Isaiah to attend law school years earlier, approached him afterward. "You handled that beautifully," she said. "The students needed to hear that justice isn't always comfortable or neat. Sometimes it requires difficult decisions and tolerance for ambiguity." "Professor, do you think this will last?" Isaiah asked. "The reforms, the changed culture, the accountability mechanisms, or will it fade when attention moves to the next crisis?" Morrison smiled. "That depends on people like you staying engaged, holding institutions accountable, and refusing to let progress slip backward. Permanent change requires permanent vigilance." As December progressed toward the holidays, Isaiah reflected on the year that had transformed so dramatically from that Thursday morning in March. He'd walked into a courtroom expecting routine proceedings and instead encountered injustice that became the defining case of his career. The settlement had brought financial compensation, but money wasn't what motivated Isaiah. The consent decree, the policy changes, the cultural shifts within the police department, those were the real victories because they created infrastructure for ongoing accountability. But Isaiah also carried costs. The public scrutiny had been intense and often vicious. He'd received threats from people who viewed him as attacking law enforcement. His face was recognized everywhere he went, making anonymous, peaceful existence impossible. His private practice had grown substantially as his profile increased, but with growth came pressure. Every case now carried weight beyond its individual merits. People expected him to be perfect, to always win, to single-handedly transform systems through litigation. The expectations were exhausting. Diane Morrison noticed his fatigue during their end-of-year planning meeting. "Isaiah, you've accomplished something remarkable this year, but you're running on empty. You need to take care of yourself or you won't be able to continue this work." Isaiah knew she was right. The adrenaline that sustained him through 6 months of litigation had faded, leaving exhaustion in its wake. He took 2 weeks off during the holidays, the first extended break since opening his practice. He traveled to nowhere in particular, staying in small towns where nobody recognized him, reading books unrelated to law and allowing his mind to rest. During that quiet time, Isaiah thought about the larger meaning of what had occurred. One moment of injustice had catalyzed change because the right elements aligned. Video, documentation, a judge willing to act decisively, media attention, community support, and his own legal expertise to channel outrage into structural reform. But how many similar moments occurred without those elements? How many people experienced discrimination without cameras recording, judges intervening, or resources to pursue litigation? The question haunted Isaiah because he knew the answer. Thousands, probably millions. His case was exceptional, not because the injustice was unique, but because the response to it was unusual. That realization carried both encouragement and burden. Encouragement because it proved change was possible when systems functioned properly. Burden because it highlighted how rare proper functioning actually was. The first anniversary of the courtroom confrontation arrived with spring weather and significant milestones in the ongoing reform process. Isaiah stood once again in courtroom 4B, this time for a ceremonial hearing, marking the completion of Phase 1 of the consent decree implementation. Judge Sullivan presided over proceedings that included representatives from the Chicago Police Department, the independent monitor overseeing reforms, community advocates, and civil rights attorneys who'd worked on the case. The independent monitor, Dr. Rachel Kim, presented her first annual report. The document ran 180 pages and included comprehensive analysis of every reform requirement. The Chicago Police Department has demonstrated substantial compliance with Phase 1 requirements, Dr. Kim reported. Of the 47 specific mandates, 43 have been fully implemented, 3 are in progress, and 1 requires additional time for data collection before assessment can be completed. She detailed specific improvements. All courtroom security officers had completed 40 hours of specialized training in implicit bias, de-escalation, and appropriate professional conduct. The screening process for assignments had identified and reassigned 12 officers whose complaint histories suggested poor fit for courtroom environments. 0 incidents of inappropriate physical contact between officers and attorneys had occurred since implementation. Civilian oversight mechanisms were functioning and had processed 23 complaints with transparent investigation and resolution. Perhaps most significantly, Dr. Kim concluded, the cultural shift within the department is measurable. Officer surveys show 67% believe the reforms have improved their ability to do their jobs effectively. That's remarkable given initial resistance to changes. Deputy Chief Franklin, who'd been promoted to Chief of Department Operations, addressed the court next. A year ago, many of us viewed these reforms as punishment imposed from outside. Today, I can honestly say they've made us better at our jobs. Officers feel more confident navigating complex situations because they have clear guidelines and training. The community is more cooperative because trust is being rebuilt gradually, and we're seeing results in reduced complaints, reduced use of force, and increased officer safety. Franklin's words carried weight because he represented institutional perspective. He wasn't an outside critic or reform advocate. He was career law enforcement acknowledging that accountability improved rather than hindered effective policing. Isaiah was invited to speak as well. He approached the podium with mixed emotions. A year ago, I was shoved in this courtroom by an officer who made assumptions based on my appearance. That moment was humiliating and infuriating, but it was also clarifying. It demonstrated that individual incidents of injustice can become catalysts for systemic change if we refuse to accept them as inevitable. He continued, the reforms implemented over the past year prove that institutions can change when forced to confront their failures. The Chicago Police Department didn't volunteer these changes. They resisted initially. But through legal pressure, community advocacy, and eventual internal recognition that change was necessary, transformation occurred. Isaiah paused, looking around the courtroom that had become symbolic of both problem and solution. But let's be clear, 1 year of progress doesn't erase decades of harm. These reforms are beginning, not conclusion. Maintaining and expanding progress requires continued vigilance, continued accountability, and continued willingness to confront uncomfortable truths about how institutions function. After the hearing, reporters sought comment from everyone involved. Jessica Holloway, who'd covered the story from the beginning, asked Isaiah the question that had been following him all year. Mr. Bennett, have you had any contact with Kyle Brennan since the settlement? No direct contact, Isaiah replied, but I'm aware he's completing the requirements of his agreement and working toward a different career path. I hope he's genuinely changed. Forgiveness doesn't require forgetting, but it can coexist with accountability. That evening, Isaiah attended a community celebration organized by Reverend Hayes. The event at a Southside community center brought together people affected by police misconduct, advocates who'd fought for reform, and officers committed to improved policing. The gathering reflected coalition building that extended beyond Isaiah's individual case. His lawsuit had been one piece of a larger movement, demanding accountability and reform across law enforcement. Pastor Gloria Henderson, who'd organized families affected by police violence, spoke about the broader context. Isaiah's case got attention because he's an attorney, because it happened in a courtroom, because it was recorded. But thousands of people in our communities experience similar treatment every day, without cameras, without lawyers, without judges intervening. We celebrate this progress while remembering everyone who didn't get justice. Her words were a sobering reminder that reform was ongoing work, not achieved victory. Kyle Brennan watched news coverage of the anniversary events from his apartment. He'd completed his community service, finished mandatory counseling, and enrolled full-time in social work classes at community college. His life looked nothing like it had a year ago. The uniform was gone, the authority vanished, the identity he'd constructed around law enforcement dismantled. In its place was uncertainty, humility, and gradual understanding of the harm he'd caused throughout his career. His therapist, Dr. Cross, had assigned him to write letters to people he'd mistreated during his 14 years as an officer, not to send, just to write as exercises in acknowledging harm and developing empathy. Kyle had filled notebooks with these letters, to Terrence White, to Leonard Hughes, to Mrs. Eleanor Hayes, to dozens of people whose names he barely remembered, but whose lives he'd impacted through escalation, assumption, and aggression. I assumed you were lying when you questioned my authority, he wrote to one. I escalated a traffic stop into a violent confrontation because I couldn't tolerate perceived disrespect. I used force not because you were dangerous, but because I viewed your resistance to my commands as unacceptable. The exercise was painful, but necessary. Each letter forced Kyle to confront specific choices he'd made and their impacts on real human beings. The documentary he'd participated in premiered at a film festival in late March. Alicia Torres, the filmmaker, had created a nuanced portrait that avoided simple narratives of redemption or condemnation. The film showed Kyle's behavior from multiple perspectives, his own justifications, the experiences of people he'd mistreated, the institutional factors that enabled his conduct, and his current attempts at transformation. Reviews were mixed. Some praised the complexity and refusal to provide easy answers. Others criticized giving platform to someone whose conduct had caused harm. Isaiah attended a screening curious about how the project had turned out. Watching Kyle describe his thought process during the courtroom confrontation was difficult. Hearing him acknowledge biases he'd previously denied was somewhat satisfying but insufficient to erase harm. After the screening, a young black woman approached Isaiah. She identified herself as Rachel Porter, sister of Kevin Porter, the teenager Isaiah had successfully defended as a public defender years earlier. "Mr. Bennett, my brother saw the news about your case. He wanted me to tell you that if you could stay calm when that officer shoved you, he could stay calm when police stopped him for no reason. Your example gave him a strategy for surviving encounters that might otherwise escalate." Isaiah felt the weight of that responsibility. His response to injustice had become a model for others. Facing similar situations, the pressure to always be perfect, always composed, always strategic, was crushing. "Thank you for telling me that," Isaiah replied. "But please tell your brother that staying calm shouldn't be required to avoid violence from police. The problem isn't how citizens respond to mistreatment. The problem is the mistreatment itself." Rachel nodded. "He knows that. But in the moment, when you're scared and a cop is aggressive, knowing that staying calm might save your life is important." The conversation highlighted paradox at the heart of these issues, teaching people strategies to survive injustice while fighting to eliminate the injustice itself. Both were necessary, but the latter was more important. April brought new challenges. A coalition of conservative groups filed a federal lawsuit challenging the consent decree, arguing it violated the Chicago Police Department's rights and imposed unreasonable burdens on law enforcement. The lawsuit was financially backed by organizations opposed to police reform, viewing the Chicago consent decree as dangerous precedent that could spread to other jurisdictions. Isaiah's legal team prepared to defend the consent decree. The case would argue that court-ordered reforms were necessary response to documented constitutional violations and that the department's compliance demonstrated feasibility and effectiveness. Judge Elizabeth Warren, who'd overseen the original civil rights case, was assigned to the challenge lawsuit as well. In preliminary hearings, she expressed skepticism about claims that requiring officers to treat people without bias constituted unreasonable burden. "The reforms at issue," Judge Warren noted, "require police officers to perform their duties without discriminating based on race. That's not an additional burden. That's a constitutional baseline." The challenge lawsuit would take years to resolve, but initial rulings suggested the consent decree would survive legal attack. Meanwhile, Isaiah continued his private practice with renewed focus on systemic reform cases. The Brennan case had demonstrated that individual incidents, when properly litigated, could force institutional change. He assembled a team specifically dedicated to pattern and practice cases, documenting systemic failures, analyzing data, building comprehensive challenges to institutional conduct rather than just individual complaints. The work was ambitious and resource-intensive, but philanthropic organizations interested in criminal justice reform provided funding, recognizing Isaiah's track record of turning litigation into lasting change. By summer, his firm had filed 3 additional major cases, one challenging school discipline practices that disproportionately impacted black students, one targeting predatory lending by financial institutions in minority neighborhoods, and one addressing healthcare disparities in public hospitals. Each case used the template developed during the Brennan litigation: individual victim with compelling story, comprehensive data demonstrating systemic problems, and legal theories demanding institutional reform rather than just individual compensation. Isaiah's mother, Ruth, watched her son's expanding work with pride tinged with concern. "Baby, I'm proud of what you're doing, but you're taking on powerful institutions that don't want to change. Be careful." Mom, remember what you taught me. Sometimes being smart enough to survive it and strong enough to change it means accepting risks. I can't do this work safely. I can only do it effectively. Ruth understood. She'd raised her son to fight injustice, not to live comfortably by avoiding challenges. But motherly instinct toward protection never disappeared, regardless of how accomplished children became. March arrived again with the second anniversary of the courtroom confrontation. The incident had faded from daily news coverage, but its impacts continued radiating through law enforcement, legal education, and community organizing. Dr. Rachel Kim's second annual report on consent decree implementation showed continued progress with some emerging challenges. The Chicago Police Department maintained strong compliance with most requirements, but cultural resistance persisted among segments of the force. The officers who embraced reforms early are thriving, Dr. Kim reported. They appreciate clear guidelines and training that helps them navigate complex situations. But approximately 20 to 25% of the force remains resistant, viewing reforms as attacks on law enforcement rather than improvements to it. This resistant minority created ongoing friction. Some engaged in work slowdowns, processing fewer arrests and traffic stops to demonstrate their belief that reforms made proactive policing impossible. Others filed grievances through the union challenging specific training requirements or oversight mechanisms. Chief Franklin addressed the resistance directly in his annual address to the department. To the officers who believe these reforms are punishment, I want to be clear, you're wrong. What we're doing is aligning our practices with constitutional requirements and community expectations. That's not punishment. That's professional evolution. He continued with tougher message. And to any officer who can't perform their duties while treating people with dignity and respect, I encourage you to find a different career. This department is moving forward with or without you. Franklin's bluntness reflected growing confidence that reforms had sufficient institutional support to withstand internal resistance. The majority of officers had adapted successfully, and results spoke for themselves. 2-year data showed sustained improvements. Use of force incidents down 44% from pre-reform baseline, citizen complaints reduced by 39%, officer injuries during confrontations decreased 27%, and community trust metrics improved 31% based on regular surveys. Perhaps most significantly, recruitment had improved. The department had struggled for years to attract diverse, educated candidates. The reforms had made the Chicago Police Department more attractive to exactly those candidates because they signaled institutional commitment to professional, constitutional policing. Isaiah marked the anniversary quietly, taking time to reflect on how much had changed and how much work remained. His practice had grown to 15 attorneys and support staff, all focused on civil rights litigation and systemic reform cases. The school discipline case had settled with comprehensive agreement, requiring Chicago public schools to eliminate suspensions for minor infractions, implement restorative justice practices, and provide data transparency about discipline decisions. Early results showed substantial reductions in suspensions, particularly for Black students, without corresponding increases in safety incidents. The predatory lending case was moving toward trial. Financial institutions fought aggressively, but discovery had produced damning evidence of intentional targeting of minority borrowers with higher interest rates and worse terms than similarly situated white borrowers received. The healthcare disparities case had sparked legislative action. State lawmakers introduced bills requiring public hospitals to report quality metrics by race and ethnicity, creating accountability for institutions that provided substandard care to minority patients. Each case followed the pattern established during Brennan litigation: identify systemic problem, document through data and individual stories, pursue legal theories demanding institutional change, build public pressure through media and organizing, and negotiate or litigate toward enforceable consent decrees or settlement agreements. The approach was working, but it was exhausting. Isaiah had hired talented associates and delegated significantly, but ultimate responsibility remained his. Every strategic decision, every settlement negotiation, every media appearance required his attention. Diane Morrison had become his most trusted partner, effectively functioning as co-counsel on major cases. Jerome Franklin specialized in data analysis and expert witnesses. Together they'd built a formidable litigation team, but success brought new pressures. Other attorneys across the country sought Isaiah's advice on similar cases. Civil rights organizations wanted him involved in their initiatives. Community groups requested his presence at events and fundraisers. Law schools invited him for speaking engagements. The demands exceeded what any human could reasonably meet. Isaiah struggled with saying no, feeling obligation to help everyone seeking assistance in fights against injustice. His sister Alicia, now a clinical social worker, recognized the signs of burnout before Isaiah did. "You're trying to solve every problem and help every person," she told him during dinner at their mother's house. "But you can't sustain this pace. You're going to collapse if you don't set boundaries." "People need help, Alicia. If I have resources and expertise to assist, how can I say no?" Because saying yes to everything means eventually being effective at nothing. You need to prioritize, delegate, and accept that you can't carry the whole world on your shoulders, Alicia finished, her tone both gentle and firm. Isaiah looked at his sister, recognizing the truth in her words. He had built a firm that was no longer just his, yet he still treated every battle like a personal mission. The weight of reform, litigation, and expectations pressed against him constantly. That night, Isaiah sat alone in his apartment with stacks of files spread across the table. He thought about Alicia's warning and considered how many cases had reached him precisely because people believed he could succeed where others had failed. He realized he had to decide whether he would keep running himself to the edge of collapse or build structures that could outlast him. By early spring, he began shifting responsibility within his firm. Junior attorneys were elevated to lead roles, community organizers were brought in as liaisons, and partnerships with national civil rights groups expanded the scope of the work without leaving Isaiah personally at the center of every fight. It was difficult to step back, but necessary. For Kyle Brennan, the second year of transformation brought both clarity and struggle. His coursework in social work was rewarding, but he still carried the weight of stigma. Some classmates avoided him when they learned he was a former police officer, dismissed for misconduct. Others approached him with skepticism, unsure if his self-proclaimed change was genuine or convenient. Kyle didn't blame them. "Skepticism is fair," he admitted to Dr. Cross in a counseling session. "I've got years of proof I was the problem and only 2 years of saying I've changed. If I were them, I wouldn't trust me either." Dr. Cross encouraged him to keep showing consistency rather than seeking immediate redemption. "Trust is earned over time," she reminded him. "Your willingness to stay in discomfort without demanding absolution is part of the work." Meanwhile, Chief Franklin continued battling cultural resistance inside the Chicago Police Department. The reforms were yielding measurable progress, but the minority of officers who resisted still generated tension. Some quietly undermined the new systems. Others lodged constant grievances. Franklin faced them head-on, knowing that leadership required persistence, not popularity. As the second anniversary passed, both Isaiah and Kyle stood at crossroads. Isaiah was building a sustainable movement beyond himself. Kyle was learning that redemption was not a single act, but a lifetime of choices. And Chicago itself was discovering whether reforms could take root deeply enough to survive the next inevitable crisis. By the third anniversary of the courtroom confrontation, the national climate around policing had shifted yet again. New political leadership in Washington brought renewed challenges to federal oversight of local departments. Conservative organizations doubled their efforts to dismantle consent decrees, framing them as overreach that handcuffed police officers. Chicago's consent decree became a test case. The lawsuit challenging its constitutionality had advanced to the appellate level. Lawyers for the Fraternal Order of Police argued that mandatory bias training, independent monitors, and civilian review boards infringed on officers' rights and imposed unreasonable burdens. In a packed appellate courtroom in St. Louis, Isaiah sat at counsel's table with a team of civil rights attorneys. Across the aisle, high-priced lawyers for the union painted the reforms as obstacles to effective policing. The stakes were enormous. If the consent decree fell, not only would Chicago slide backward, but other cities would lose a blueprint for reform. Judge Warren's words from earlier hearings echoed in Isaiah's mind. The Constitution does not protect the right to discriminate while wearing a badge. He carried that clarity into oral arguments. When it was his turn, Isaiah rose and addressed the panel. The measures being challenged here are not punishments, they are safeguards. Every provision is aimed at ensuring that officers exercise authority in compliance with the Constitution. If these safeguards are burdens, then the burden is the burden of accountability itself, and that is the foundation of public trust. National media covered the hearing extensively, framing it as a battle between two visions of law enforcement. One clinging to unrestrained authority, the other insisting on constitutional limits. Meanwhile, in Chicago, the reforms continued to function. Community trust surveys climbed higher, and officer safety statistics remained strong. But the uncertainty of the appellate ruling hung over everything. Would years of progress be unraveled by a single court decision? Kyle watched the coverage with mixed emotions. His own journey was inseparable from these reforms. If they were dismantled, his story risked becoming a footnote rather than part of a larger transformation. For Isaiah, the legal battle represented both professional challenge and moral test. Losing meant not just legal defeat, but betrayal of every citizen who had placed faith in the possibility of lasting change. 3 years after the confrontation, Kyle Brennan no longer looked like the officer who had shoved Isaiah in a courtroom. His hair had grown longer, the rigid posture softened, his demeanor slower and more reflective. He had nearly completed his degree in social work, interning at a community program that provided counseling for at-risk youth. The work was demanding. Many of the teenagers distrusted him instantly when they learned his past. "You're a cop," one boy told him flatly. "You don't get it." Kyle didn't argue. Instead, he listened. Over time, some of the kids began to see that he wasn't there to control them, but to understand them. One afternoon, Kyle sat with a 15-year-old named Marcus, who had been suspended from school for fighting. "Why'd you throw the punch?" Kyle asked. "Because he disrespected me," Marcus said. Kyle nodded slowly. "I know that feeling. I used to think every bit of disrespect meant I had to prove something. It only ever made things worse." Marcus frowned. "So what? I'm supposed to just let people walk over me?" "No," Kyle said gently, "but there are ways to stand up for yourself that don't destroy your future. Trust me, I destroyed mine by reacting the wrong way too many times." Moments like these were both painful and redemptive. Kyle saw himself in these kids, but he also saw an opportunity to break cycles he had once reinforced. Outside of work, his life was quieter. He lived modestly, still attending therapy with Dr. Cross, still participating in community panels about police reform. The documentary featuring his story had made him a reluctant public figure. Some accused him of exploiting his past for sympathy, while others saw him as evidence that even the most entrenched biases could be unlearned. Kyle didn't care much about perception anymore. "Redemption isn't about people clapping for you," he told his father one evening. "It's about whether the people around you are safer and better because you changed." Dennis, now in his 70s, had softened too. Watching his son's transformation forced him to reconsider his own decades in law enforcement. For the first time, he admitted that some of his old-school lessons had caused harm. "I taught you wrong," Dennis confessed quietly, "but maybe you'll teach the next generation right." As Isaiah fought legal battles in appellate courts, Kyle quietly built a new identity, one not anchored in authority, but in service. Their lives no longer intersected directly, but the ripple effects of their confrontation continued shaping both men in ways neither could have imagined on that March morning years before.